How do you negotiate artificial intelligence related contracts when there really is no roadmap for how to negotiate those types of commercial contracts? My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I've drafted and negotiated a variety of technology related contracts and litigated failed technology projects in courts across the country. The agreements presented by most artificial intelligence vendors mostly trace a standard software licensing and software services delivery model, but often those types of agreements don't really contemplate the technology nuances that are specific to artificial intelligence related technology. While a software licensing model is a good basis for acquiring AI functionality, it's a good start, there are going to be substantive differences between a software license that's geared towards certainly SaaS or commercial software versus generative AI or artificial intelligence in general. I think what you're going to want to focus on, at least preliminarily, are things like definitions, license restrictions. You're going to want to look at expanded warranties and representations associated with the artificial intelligence and associated with the data that you might be putting into the artificial intelligence functionality. You're going to want to look at, really pay particular attention to indemnity obligations and making sure that they work in the context of the provision of AI services or AI functionality. You're going to also want to look at the carve-outs to limitation of liability. The way that I like to conceptualize this when I'm looking at one of these contracts is in relation to inputs and outputs. You want to think about what kind of information and data that you're inputting into the AI functionality. For example, customer data. If you're inputting both your data and your customer's data into the AI functionality, you're going to want to have a very good understanding, essentially, of what the scope of use is to that information. You're going to want to understand what the vendor can do with it, and you're also going to want to understand what your obligations and warranties are with respect to any kind of data that you're going to be putting into the AI functionality. I think what's typical is for vendors to require that the customers warrant, or that their customer, you, warrant that the customer data that is going to be utilized by the artificial intelligence tool is accurate and complete, and that the customer has all the necessary rights and consents to provide that customer data to the vendor for the particular use that's contemplated under that agreement. And I think depending on how broad the use is and how structured the utilization of that data is going to be, this may require for you to get consent or even make disclosures under applicable privacy laws. The other bucket of input that I think you want to consider as you look at these agreements really is third-party data. And vendors are going to utilize third-party data for training and development purposes of their large language model. So, in this context, we're not looking at the data that you're inputting into the system, but we're looking at the data that the AI vendor has incorporated into their tool and that they're training the tool on. Where did they get this data from? Is it publicly available information off of the internet? Is it going to be from other customers? Is it is it a closed system, an open system? And you're going to want to have some sort of a representation or warranty with respect to that data. You want to have an understanding. Do they own the data? Do they have a right to utilize that data? Is that data infringing? And I think this is where some of the nuance associated with these contracts come in. It may not be a traditional indemnity model that you would normally see in a SaaS contract, for example. I mean, I think certain vendors, AI vendors, may have some issues making certain representations and warranties that you would traditionally see in a standard contract. One of the other things that you want to consider as part of the bucket of inputs is what happens to user prompts. And these are the prompts that you're utilizing to generate outputs from the artificial intelligence tool. There could be a lot of value associated with the inputs that you're utilizing to generate outputs from the functionality, and there may be a need for you to have some ownership interest in those, or alternatively, if you're actually inputting as user prompts confidential or proprietary information, you want to have an understanding of what happens to that data, and that data is protected and that you have some recourse to either get that data back or hold someone to account in the event that that data is utilized in a way that's not contemplated by the agreement. So those, I think, are the inputs in general. You also want to think about what the outputs are. You want to have an understanding of the elements of these outputs. What are the outputs made up of, and who is going to own the output that is coming out of that functionality. So, for example, you're putting in your data, your customer information into this, and now what comes back is substantive analysis that's going to give you a competitive advantage. What are you going to do with that, and who is going to own it? One of the other things that you want to think about is the concept of infringement claims regarding the use of data to train that model. Is there an infringing use of data that the AI vendor has made in connection with training its model? Is this going to be similar to kind of an ordinary course infringement indemnification? Probably not. You also want to think about the implications of trade secret and proprietary information and confidential information. I think you're going to need to be highly cognizant of the type of data that you're putting into the model and the sensitive nature of that data, and you're going to want to put in policies and prohibitions to make sure that you're not disclosing confidential or proprietary information unnecessarily or at all. So look, I think the concept of how to contract with artificial intelligence vendors is an evolving subject, and it's one of the dynamic areas of the practice of technology law. And I think it's certainly going to evolve over time, but I do think there are kind of guideposts in place already that attorneys can use to inform their negotiation of these types of agreements. And I do think that at least to some extent you can look at traditional software licensing models kind of as a base for guiding you in your negotiation with artificial intelligence providers. I don't think it's the be-all and end-all, and I do think you've got to pay particular attention to a lot of the nuanced issues that artificial intelligence creates and presents from a risk mitigation standpoint and really from a litigation standpoint as well. If you're negotiating with an AI vendor, or you've got any questions about any of the issues that we brought up in this video today, please feel free to reach out to us. We'd love to talk to you about it and get you pointed in the right direction.